1 on the dot, and I'm Liz from AmCham Abu Dhabi, and thank you for waiting to join this amazing Legal Affairs Committee event. They are kicking off 2022 with a fantastic program brought to you by Accenture, Afridi Angel, and Fragaman. And I'm going to hand it over to my dear friend who's celebrating a birthday today and a founding member of AmCham, Mr. John McGowan. John, take it away, sir.
Thank you very much, Liz. Well, I'm very excited today because we have a fantastic program and an amazing panel on subjects that I believe are going to be of great interest to people beyond just the Legal Affairs Committee of AmCham Abu Dhabi. Major changes in the UAE employment law and developments in visa and immigration, which we all should be aware of. And so there's a lot going on now in the legal space, and it impacts all of us who are living and working in the UAE. And, for those of you who don't know me, as Liz mentioned, I'm John McGowan. I'm a founding member of AmCham Abu Dhabi, counsel with Global Advocacy and Legal Counsel here in the UAE, a local law firm. Formerly a member of the board of directors and secretary of AmCham. And over the years, I've seen a lot of issues in both the immigration, visa, and employment law space. And the panel we have today is going to inform us about the latest changes in the law and also answer any questions we all may have. So we have 3 members of the panel. Charles Lalbach is a good friend and a partner at Afridi and Angel. Charles has lived in the UAE since 1986, both in Abu Dhabi and Dubai. Charles's law firm, Afridi and Angel, was a founding member of AmCham Abu Dhabi, which formally organized in 1990 and was formally recognized by the Abu Dhabi government in 1996. Charles served on that AmCham board, first as chairman, and thereafter served on the board for several years. And this is very interesting. Charles is one of only 5 recipients of the Ambassador's Award, which Ambassador David Litt awarded to Charles in 1996 in recognition of his leadership role in support of American business interests and in the formation of AmCham Abu Dhabi. In addition, Charles has been a member of AmCham Dubai since its establishment in 1986. He has served on 2 occasions as its vice president of legal affairs and secretary. Charles is a partner at the law firm of Afridi and Angel, a corporate member and corporate founder of AmCham Abu Dhabi. So welcome, Charles. We also have Abir Al-Husseini, who's a partner at Fragaman. Fragaman, one of our platinum members. We're so happy to have Fragaman weigh in on so many important issues, and this, of course, is one of them. Abir is a partner at Fragaman's Dubai office, where she has been a member of the UAE inbound immigration team for 12 years. Abir uses her extensive knowledge of immigration requirements and the various UAE jurisdictions to assist UAE-based companies with their immigration and compliance needs. Abir assists clients from a variety of industries, including construction, IT, media, oil, and gas. She helps companies redesign their existing immigration models to ensure maximum efficiency, as well as implementing process improvements. In addition, Abir has managed the immigration-related aspects of a number of high and medium volume projects involving M&A, spin-offs, and other types of corporate restructuring activities. Prior to joining Fragment, Abir worked in government and diplomatic services. Abir speaks Arabic and English. Welcome, Abir. And we also have on our panel another Liz, Liz Williamson, Senior Counsel, Employment Law, Middle East and Africa at Accenture, Middle East and North Africa. It's so wonderful to have Accenture on board because you deal with so many issues. Your company, Liz, and Liz is a UK qualified employment lawyer and certified information privacy professional based in the UAE. After 10 years in private practice in the UK, South Africa, and the Middle East, Liz moved in-house and joined Accenture, where she is responsible for employment and immigration law, strategy, and compliance across the Middle East and Africa. As part of her role, and get this, as part of her role, Liz works closely with Accenture's mobility team to support a 500,000 plus globally mobile workforce. That's 500,000. That's quite impressive. Liz is also part of a team focused on strategic employment law initiatives, including Accenture's COVID response and the future of work. We're anxious to hear about that, Liz. And works as an investigator within Accenture's Accenture's Conduct Counts Matters teams. So Conduct Counts Matters team, addressing conduct-related matters in the workplace. Liz is a passionate inclusion and diversity and ESG advocate and sits on Accenture's Inclusion and Diversity Committee and co-chairs ACC MENA's ESG working group. She is excited by the potential of digital to drive societal change. Quite impressive indeed. So I'm so impressed with this panel, and forgive me for perhaps going in a little more detail, but we have the real deals here, folks, who are going to opine and educate us as to what's happening. The Legal Affairs Committee, some of us had a quick powwow yesterday as to where we should start. So we thought we would start with immigration and visa issues. So if Abir, you have the floor for about 10 minutes, if you can talk a little bit about those issues to get us started here.
Sure, thank you, John, and may I say happy birthday. Thank you for spending your special day with us.
Thank you so much. Thank you.
As you said, you know, we've been having over years complexities and sort of certain issues with the immigration due to limitations of what was available from immigration landscape. As we said, we were talking yesterday, and I was telling you I've moved here 14 years ago, and at the time, the only possible option for you to travel to the UAE were the traditional employment visa or a typical short-term tourist visa, business visa, a dependent visa. And for some time, this is what was available. And when I look now at what we have from an immigration options perspective, it looks like we have a bouquet of options available. There are definitely a lot of eligibility criteria. There's a lot of options to meet the needs of what the economy that's developing very rapidly and that's quite agile requires and needs, and also to accommodate some of those newer generations professions, if we may say as well, that foster a lot of freedom of lifestyle and requires to be a bit more flexible. So before I go into that, just a quick roundup of some of the changes that happened in Q4 2021. And there was quite a lot of changes in 2021, so we can't cover all of them, but just some of the highlights in the last quarter. Mainly that there was a new federal law on the foreign nationals' entry and residency, which is usually a new immigration law, if you want to keep it short. This new law replaced the existing 1973 law and any subsequent amendments that it had effective immediately. It also assigned the Federal Authority for Identity, Citizenship, Customs, and Port Security to enforce this law. Now, I'm going to keep referring to it as immigration, just for ease reference to the slide, as it may be a mouthful to take the full terminology, but just as an FYI, from a technicality perspective, it's now with FICAPS. The law didn't necessarily have any substantial change to the UAE immigration process. It just sort of further put an expansion or further described the requirements for a lawful UAE entry and the obligations of the foreign nationals when it comes to extending their residency, departure, and any activities that they perform while staying in the UAE. It also elaborated on the violations that may occur in case this law has been not met or individuals were found non-compliant, and it provided the authorities the right to cancel any visa for reasons including public security or breach of the immigration regulations. Another notable change was that freelance visas, an already existing category in some jurisdictions, is now available at federal levels in the UAE or overseas, specifically for fields such as artificial intelligence, blockchain, and digital currency. This is obviously to attract further talent in those specific industries and in those specific skills. A Dubai-specific notable change was the 5-year visitor visa for tourism and international business travel, and we'll speak a little bit more about it. But this is a program that basically would allow businesses to obtain a 5-year visa to Dubai for all of their professionals seeking frequent travel to Dubai for business needs. It makes it much easier for those who have business meetings quite regularly in Dubai and not to have to worry about prearranged permits. There's limited, there's not full clarity on what business activities can be conducted, but it's safe to say meetings and hands-off business activities are okay. Further information may be needed and checked for more hands-on business activities. Also, a little bit from a procedural side, there has been some changes to the UAE national ID processing. I think this was the reason why we put it as notable. It was quite disruptive for a lot of businesses. One, because in a lot of the jurisdictions, while Emirates ID used to be processed with your residence permit, now it has to follow your processing. So once your permit is complete, you process the Emirates ID. This is not across the board, but it's in some jurisdictions. The other change is that, and this is where it was quite disruptive, is that there has been new specifications to some of the documents that you provide to process your Emirates ID, including a photo, which caused a lot of disruptions and delays in the process itself. Last but not least, the introduction of NAFIS, which is an Arabic word that means compete. It is a program that is thought to provide and increase the competitiveness of the Emirati human resources and empower them to occupy more jobs in the private sector, just to align with the UAE government goals for 2025 of 75,000 UAE nationals in the private sector jobs, as well as the 10% increase that is specific for that year. It subsidizes the UAE nationals' salaries, pensions, and just sort of further incentivize the private sector to tap into the skills and the pool of UAE nationals. Now, just jumping into what are the options available from an immigration perspective for the UAE. And we're not going to discuss here the traditional employment residence permits. I think we're all sort of quite familiar with those. A lot of us have had few rounds of issuing those and renewing them, canceling them, transferring. But we're going to look into some of the other options, specifically on residents, and just touch lightly on visitors. On the residents side, not all of those are new. However, some of them have been there for 5+ years, but they have resurfaced and got a little bit more into the limelight recently, either because they were made more publicly available or because there has been further flexibility and efficiencies in the process. That definitely describes the long-term residence permits, or the celebrity of them, as we call it now, the Golden Visa and the Silver Visa. Golden Visa being the 10 years, and the Silver Visa, probably not as commonly used terminology. Everybody focus on the Golden, but Silver Visa being the 5 years category of the longer term visas. Remote work permits. This is a child of, I would say, the pandemic. It was launched in 2020 in the last quarter, and we're going to touch in more details as well about it. Other options that has been there and more efficiencies has been involved, such as the investor visas, which they can go from anything between 2 years to 10 years, available across multiple jurisdictions in the UAE, in different emirates, and depending on what exactly the individual is looking to invest in. They cover anything from setting up your own company up to investing in a portfolio of funds or in assets and properties. Retirement visa, which speaks really greatly to the diversity of population that the UAE is looking at, providing options as well for individuals who are seeing Dubai as a safe haven or a nice place for them to retire, giving them a solution to stay post all of the years that they've spent in Dubai once they are no longer looking for employment. And then freelance visas and other categories. There's quite a lot of them, such as the widowed visa, divorcee visa. As I said, looking to perhaps cater for the diversity that Dubai is looking to achieve. And then visitors, we're going to touch on some of the long and short-term options that are now available. So without further ado, probably it's appropriate to speak about the long-term permits, which are the ones that are currently receiving quite a lot of coverage with our clients, a lot of interest and a lot of surges in processing those, which are the golden visas and the silver visas. As said, those are probably launched 5+ years ago, and they've become more available for public earlier in 2021, where nominations were open both from government nomination as well as self-nominations. Long-term visas are there for foreign nationals and their families. Applicants who would want to see their eligibility for that are usually your applicant would be a senior executive, scientists or individuals who have studied specific sciences or exceptional talents, doctors, engineers, entrepreneurs, and certain investors that hold specific type of funds in the UAE. That's usually a mix of your property as well as investment funds. The reason this has now obviously had sort of a booster is because the nomination process was now open from being just select names where the government needs to endorse, and more open specifically on the executives levels for companies to approach either the authorities or directly themselves apply via the ICA portals for their executives to obtain a 5 or a 10-year visa. So what usually the government is looking for, specifically at the executive level, which is the most sought after category, is individuals who earn a minimum of 50,000 UAE dirhams per month. Obviously, the individual needs to have had spent a number of years in the UAE, typically 5 years. However, it's always subject to the review of the individual's portfolio and their contribution to whether the company or to the economy. And it's obviously, given the name, looking for very senior executives. A sticking point usually with those is many companies would have a variation between what your residence permit title is versus what your internal title. That can cause some minor roadblocks depending on the nomination and the portfolio of the person. Sometimes that can be resolved. Unfortunately, other times it cannot. How usually we are observing nominations go through, as I said, either you go through a government nomination, meaning a specific company can approach a government body. Just as an example, the Dubai, in Dubai at least, the Dubai Tourism Authority, or they can approach a ministry like a Ministry of Information, regardless of the emirate, and they can provide them a portfolio of what they have done in the UAE and their contributions. They'll also then inform them of their willingness to support a number of their executives and their employees for the longer term visa categories, and provide bios and specific paperwork just to prove that, you know, those individuals are indeed eligible for this elite residence permit option. From a compliance perspective, because this is a self-sponsored visa category, regardless whether your employer approached a government department to apply for it or whether you have directly applied for it, because this is a self-sponsored category, employers need to make sure that they are, once the process is complete and their executive has been issued a UAE long-term residence option, whether it's golden or silver, that they are getting and procuring the correct work authorizations. Me and Charles yesterday were talking about the difference between right of residence versus of right of work. So those longer-term residence options provide you the right of residence. If you are employed, you're still required, based on the jurisdiction you are in, to obtain the right of work, and that can be a labor card, a free zone card, again, depending on where you're employed.
Abir, excuse me, there's a word on the street is that some of the players out in Silicon Valley in California, a few of very high net worth individuals have moved to Dubai more or less permanently. They shifted their residence and moved their families, you know, which is certainly a testament to the UAE and the whole issue of safety and opportunity. What kind of visa would individuals in that category or near that category be? Would that be a golden visa opportunity, or could they use something else?
Oh, that's a great question. I think it ties really nicely as well to the next slide that we're going to look at. So I cannot comment on this particular group. Yeah. However, you know, this group can either be eligible for the longer term visa options, which is the golden visa and the silver visa, while they may not necessarily be able to provide the proof of being there in the UAE if they're coming from a background that will, you know, be giving back to the UAE economy and, you know, be actively participating in its growth, that their profile may be considered. But another amazing category that such professionals would be able to utilize is the remote work visa, or the virtual work visa, as many call it. This visa category allows professionals such as those Silicon Valley professionals to continue to do their work for an employer or a company outside of Dubai, while having the right to reside, while having the right to reside in the UAE. And I say Dubai because this is until now issued only by the Dubai authorities, because it's a program that was initiated by the Dubai tourism authorities. However, it does allow you to reside obviously anywhere in the UAE, because we know that, you know, there's freedom of residence in the UAE, regardless of the sort of Emirates issuing your permit. So this would be a really good visa category for them, depending on whether or not that they've moved the actual business to the UAE. A remote work permit allows them to keep their business in Silicon Valley, receive the remote work permit, and live in Dubai while continuing business as usual. They'll have the right to sponsor dependents, they'll get an Emirates ID, buy a car, rent their residence. So they would be living and residing in the UAE just like any other UAE residents. The only caveat there is that they would not be allowed to perform a work activity on this particular permit for a company or a business or generate revenue in the UAE itself. They should maintain their work towards the benefit of an organization that's located out of the UAE.
Do they need to, do they need to, they need to make sure they visited the Dubai at least every 6 months? That, for example, they couldn't just stay outside of the UAE
Yes.
for a year, or they could.
The general immigration rule for a permit not to sort of get deactivated is entry every 6 months. Now, we've heard, and I cannot, say that this is set in stone, that for some of those categories, such as the golden visa and the remote work permit, that there may be some flexibility around that. I haven't necessarily had a situation where that has been the case, so I cannot say for sure that this is the case. However, just keep in mind, John, that those who are applying for specifically the remote work permit scheme are individuals who actually want to reside in the UAE because of all of the advantages they get and continue to be employed outside. So generally, this requirement is not necessarily something that they've been troubled with. It's a lot of those executives who want the Dubai sunshine, the Dubai safety, the UAE living standards and the Abu Dhabi living standards and overall all of the UAE standards, but they have an employment outside that has been ongoing and it's been really well for them, and they just want for them and their families to live here.
Excellent. Good stuff.
Yeah, absolutely. If we can just move to the next slide, please. The retirement visa, another really exciting visa category that had some good changes towards the end of last year that made it even more attainable and easier for individuals who are looking for it. So this is a 5 years residency for retiring foreign nationals and their family members. And obviously there has been a retirement age set as 55 years old. I haven't seen a situation for a younger applicant that requested an exemption of that, but I'm pretty sure that, if someone is able to meet the eligibility criteria, that's a case that can be put forward, and we'll definitely do an update if we've seen that. Again, it provides the foreign national the right to fully reside in the UAE. They would not be allowed to do any work because this is a retirement category. The criteria for them to be able to enjoy this permit is generally a financial one. They need to provide a specific proof of funds. Currently an income of 15,000 dirhams. It used to be 20,000. It was revised in 2021 in November. So one of these, so either a 15,000 dirhams of a monthly income, a 1 million dirhams of savings or 1 million dirham of property value. And some of those used to be higher, but they were revised recently. Also for some applicants, being able to show a combination of savings and property worked really well, and the authorities were open to accommodate their applications on that basis. And just on, and I know we don't have a separate slide on it, but just on property visas, there has been as well in Dubai some recent changes and flexibilities where they further lowered the requirement or the criteria of minimum property value to be 750,000 dirhams to obtain and up to a 3 years residence permit. And this property can be fully mortgaged as long as the applicant can provide proof of income of at least 10,000 dirhams, which shows you a trend that the UAE is looking to implement further flexibilities and provide more options and more solutions for UAE residents to be able to go through a self-sponsorship route if needed.
Excellent. Good stuff. All right. Well, we'll aim to get back to you. I think given our time constraints, I'd like to hop over and examine our employment law changes. And thank you for that, Abir. And as I said, I'm sure we're going to have some questions on the visa matters. Charles, the floor is yours if you can embark on the discussion of labor law changes.
Sure. Let's get the slides up there. Thanks. I'll try and go through this very quickly. I'm sure there'll be questions afterwards, but let's go to the first slide, Shohrat, Liz. The big change was brought in when the authorities enacted Federal Decree Law 33 of 2021. That was enacted, I believe it came in the Gazette in October, and it is scheduled to take effect on the 2nd of February. So that is the new labor law. It replaces the old one in its entirety. So it's the old law is no longer going to be in effect after the 2nd of February. The new one will take effect. There's also a companion measure, 43 of 2021, which is designed to express some policies regarding work in general that applies both in the public and the private sector. It's also effective on the 2nd of February. So the two are companion measures, but the one that has the more detailed rules for employers, like I think most of us are, employers in the private sector is law number 33. Now, it's made, next slide, it's made a number of big changes. John, you might want to mute yourself, okay? It's made a number of big changes. One of them is there's a general requirement now that the old system of having two kinds of contracts, some for a specified term or a definite term, and some for an unspecified term, that is no longer going to be followed. And now all employers are supposed to use only specified term contracts. Now, the consequences of that are not going to be like they were before, because a specified term contract that contains a termination clause can still be terminated with notice in accordance with that clause. So it's not like it's an ironclad straitjacket, as it were. And this sort of irrational distinction, or the arbitrary one before, between unspecified and specified term contracts is gone. Termination with notice is possible, but it may be, notice may be no less than 30 days, no more than 90 days. Kind of a change for I knew a lot of our clients have like 6-month or 12-month notice periods for executives, senior personnel, because you want to have a transition time. Well, you can't do it anymore unless the regulations come out and give a little more flexibility in terms of this. But employers throughout the UAE now, governed by the labor law, are supposed to introduce specified term contracts exclusively for their entire workforce. And this is during a 1-year transition period. So between now and the 2nd or the 1st of February, 2023. And again, the sooner the better. Can you go to the next slide, please? End of service gratuity. The old formula for calculation of severance pay remains intact, but there is a little bit of a ambiguity in the way the statute is worded. This is, I mean, Federal Law 33, because it talks about an employee getting 21 working days of base salary for each of the first 5 years of employment, and then 30 quote, working days of base salary for each year thereafter, using the term working days in lieu of days. And but that is not carried over in the other statute I mentioned, Federal Law 47 of 21. So what's the intent of all that? Is it really supposed to change the calculation? You know, I don't think so. But I suppose it could be argued either way at this point. What it means, though, is that the old rules on gratuity, the calculation, it's clearly now based on base salary, not simply total salary minus this and minus that and minus that. The old definition left some ambiguity with regard to bonuses and commissions. No more ambiguity as far as that's concerned. An employee who resigns doesn't lose gratuity. An employee who is terminated for cause under Article 120, which is now Article 44, those 10 grounds of employee misconduct, that employee no longer loses gratuity either. The labor law has left unaddressed whether pensions, savings plans can replace gratuity. That is a subject that was expressly addressed in the old labor law. Now it is left to be addressed by executive regulations. So will things like dues and DIFC be available in the private sector? We don't know yet. I think so. I think they'll come up with some regulations that allow that, because to me, the general trend of all this is to make the labor law more flexible and more able to address the modern workplace. So, but we'll have to see that clarified in the executive regulations that are supposed to come out from the cabinet once the labor law takes effect. Okay, next slide. Working hours. Okay, the big news. Why are we now suddenly on a new work week, Monday to Friday? Well, there's all kinds of reasons why you would want to have a Monday to Friday work week, but the big thing here is the labor law. Up until the 1980 labor law requires that all employees be given a weekly day of rest, and that must be on Friday. Okay, that's the 1980 labor law. From the 2nd of February, you still need to give your employees a weekly day of rest, but it doesn't need to be Friday. It can be Sunday, it can be Thursday, it can be Tuesday. And so as long as you don't require your employees to work 7 days a week, I guess lawyers are exempted from that. But you know, as long as you give your workforce 1 day of rest, it can be the day you choose. It can be Friday, it can be Sunday, it can be a different day. And so a lot of employers are going to be making that Saturday or making that Sunday or making it both of those days and giving everybody a 5-day week or a 4.5-day week, as it were. You've got the flexibility now. And I'll even go further. You can even bring in flexibility so different parts of your workforce work different work weeks, because it's by the contract, right, for each employee. I know some companies that have clients in the other Arab countries, okay? And they want to keep the old work week, which is fine. You can do it, the law that lets you. Other companies, most of their clients are in Europe and America. And so they want the Monday to Friday work week. Now, the new labor law, as of 2nd of February, you can do that. You've got to do it. It doesn't happen automatically, but you can select a work week that you want for your workforce. And you can even have different work weeks for different personnel if you want to do that. Okay, next slide, please. Discrimination. A lot of the press coverage makes much of the fact that the new labor law eliminates or contains express prohibitions on sex-based and nationality-based and national origin, race, and so forth based discrimination. That was there before, okay? Those anti-discrimination provisions were there in the old labor law. There were a number of changes that were brought in 2019, 2016, if I recall. So what the new law does is continue that. So you can't discriminate between men and women anymore. You can't, pay a man and a woman different compensation if they do the same work. You can't have jobs that are only available to this gender and not that gender. You can't pay, you can't pay Canadians more than you pay Americans, things like that. So all that stuff, there's a lot of stuff out there in the market, in the real world, that goes on. There's a lot of discrimination, but the authorities are trying to get rid of that. They're trying to phase it out. And so it's a really important change, certainly in terms of cosmetics, but also in terms of, all of us want to be good corporate citizens. And when the law lets you do that, it's much easier. Okay. Post-employment restrictions, it looks like the labor law is going to open the door a little bit to the kinds of restrictions you normally want to impose on an employee who jumps ship, goes to a competition, takes a client list and all kinds of, business methods, and then competes against you. Now, right now, you can put all that in the contract. Really, really hard to enforce because the courts are still reluctant to issue injunctive relief or declaratory relief. And often it's just too late. The person's gone as a new labor permit with a new employer, and you can't do anything really. You can sue for damages, whoop-de-doo. The new labor law makes it quite clear that these provisions are permissible, and it allows them for, it didn't say before that they have to be only subject to a specific period of time, but now it does, 2 years. And so that might indicate a willingness to make them enforceable. We'll have to wait and see. It might just be a change of words and no real change in substance, but it might be meaningful too. So again, watch this space, and especially, in the UAE, watch what the judges do with these things. Because when you wind up in a court, that's where the real, impact is felt. Let me just go one more slide, please. Okay. Abir talked about all of these new visas, and effectively now, today, employment is decoupled from residency. You don't need a job to live in the UAE, right? You can retire and stay here. You can get a golden visa and stay here. You can be a self-employed property owner, all these different categories of visas let thousands, perhaps, of expats stay in the UAE without a job. Can you hire those people? Okay, can you hire those people? Are they eligible to work? If you get a golden visa, it says on the face of the visa, if I'm not mistaken, not eligible to work. Dependent visas say not eligible to work. What does that mean? It means basically this, and as employers, keep this all in mind. The visa lets a person live in the UAE. It does not authorize the person to work. If you want to hire that person, you've got to go through the normal Ministry of Labor, Human Resources process and get that person a labor permit. Sign a contract, file the contract, apply. Do that, because you've got to have a labor permit for anyone on your payroll. And if you don't, it's a violation of the labor law on the part of the employer and the employee. So those golden visas and all the rest, it's great because you can kind of forget about having to reapply every couple of years. But the employer, if you're going to hire someone like that, make sure you also go through the Ministry of Labor process, because it is required. Now, someone asked a question about what about the free zones that don't yet have procedures in place for issuing employment permits for individuals holding golden visas. That's a very good question. If they don't have those procedures yet, I hope they develop them before much more time goes by. Some free zones, I think, do allow that. I think DIFC does, for example, and a few others might. But the general requirement is that, again, the golden visa, these other visas, they let you reside, but they aren't work permits, and a work permit must be sought and obtained separately. Just don't get caught in this. It's a kind of an elementary mistake. Now you know, okay?
I'll see-
Yeah, that's all I've got to say for now. Any comments, any questions? Or do you want to move on to Liz?
Yeah, we'll move on to Liz, but a quick question first. On the non-compete provisions, I mean, or is there a rule of thumb then for the new contracts, or, should employers, as a general rule, limit it to 1 year or 2 years or 6 months? I mean, is there a ceiling there for
Yeah. The ceiling is the pure restriction on working for the competition after you leave employment is 2 years now.
3 years?
2 years, 2 years. But this is another kind of a mistake. This must be in the contract in order for that restriction to exist. It does not exist by law. It does not exist because of the the ether. It's got to be in the contract. It's a contractual right. Okay, so you got to state it in the contract, and then in order for it to even having even a chance of being enforced. But the difference is that before they didn't have this time limit in it. Now they do, and that might mean that they're more serious about enforcing it. But that remains to be seen.
Wonderful. So much good information. Thanks. And I know we're running a little short on time. At Legal Affairs Committee, we try to get done in an hour. So Liz Williamson, I know we, perhaps could use more time, but can you dive in to your subject, which is carrying on with the employment law, and anything you might want to say about the visas as well?
Yes, absolutely. Thanks, John. And I think Charles has covered like many of the changes that we as a business, as many employers are currently considering how we navigate. And as he's mentioned, like we're still waiting for much of the detail to come out under the hotly anticipated implementing regulations. So they couldn't come quickly enough, I think, in some respects. I'm going to talk about some of the additional topics that Charles didn't touch upon. And because the new labour law has been quite progressive in some ways, and whilst not all the details are out yet, it has opened the door or can pave the way for possible changes in other areas, a bit like Charles was mentioning with the non-compete change. It suggests maybe further changes coming. And a good example of that is that there is now formal recognition under the new labour law of alternative working models. And this is quite exciting if you're an employment lawyer or an HR professional, because it will start to address both the employer's need for flexibility, right? We all as employees, regardless of our industry, have a greater need for flexible work models, and we're seeing that trend globally. But it also helps to address the growing desire of employees, and I think particularly the generations accessing the workforce now, to adopt a different working pattern. What the labour law does, it formally introduces this concept of part-time work. We saw a resolution in March that started to recognise this, and there was an introduction of part-time work permits, which enabled someone to have work permits for 2 employers. But the labour law didn't address the impact of a part-time work arrangement on all benefits. It touched upon some, but not all. The new labour law expressly recognises part-time employee, and it actually references part-time employees through the labour law. And it clarifies an ability, for example, of an employer to prorate vacation where someone's working part-time. Because before we were in a scenario where the 30-day entitlement to vacation technically applied, whether you were full-time or part-time employees, you're working 5 or 2 days per week. So we're starting to get some clarity around how we should manage part-time employment relationships. It also provides for temporary work where time or a project objective is a determining factor in the length of the employment period. So this might be a new form of fixed term contract. I mean, Charles talked about how we now need to transition everyone to a fixed term contract, but we can still terminate on notice. So for practical purposes, it operates a bit like the limited term contract we were used to. But this temporary work is perhaps going to be more closely aligned with what we previously had with the fixed term contract. And then finally, it introduces the possibility of other flexible models. And this is, again, in line with changes we're seeing in working practices globally. And then the new law at the moment defines flexible work as work whose hours or days of performance change based on the volume of work and the economic and operational changes of the employer. And this would appear to imply that things like condensed hours are possible. So employees could work longer on some days and shorter on others, which is one of the ways that some employers are seeking to address the change to the working week. To accommodate, for example, a need to take an extended break on a Friday to attend prayers. But as with the change to the limit on work hours per day or the overtime trigger, it's difficult. It's difficult to implement this at the moment because we are still sitting in a position, and I saw a question pop up in the chat around, do we still have this cap on work hours per day? And at the moment we still do. So this 8-hour daily limit still exists under the new law, and that remains the overtime trigger. I think, interestingly, though, the labour law also talks about a total hours over a period of 3 weeks. I think it's 144 hours over 3 weeks. So again, it's suggesting that it's not going to be quite so strictly regulated as 8 hours a day over 5 or 6 days, and we are going to see the implementing regulations bring in some further clarification, particularly on what the implications of an alternative work model might mean for overtime pay and benefits. So, I think this is good news for employers in the UAE, and it's hopefully will allow us to respond to changes in global working practices, partly as a consequence of the pandemic. And I guess linked to this greater flexibility with hours and days and working models is the fact that the new labour law expressly recognises remote work. There's not guidelines yet concerning remote work or home working arrangements, but it does acknowledge that an employee may work remotely, and whether that's inside or outside of the country with the approval of its employer. There are, of course, immigration, tax, corporate law issues that come into play when an employer is working out whether or not it can allow someone to work remotely in another country and for how long. But I think this is, again, a development that reflects a new working environment in which we probably all find ourselves. And combined with the new remote work visa that Abir mentioned, it again, which introduced the possibility of individuals who are employed outside of Dubai coming in and living in Dubai and working remotely for their overseas employer. It really signifies the UAE is kind of setting the stage for a genuinely mobile, flexible workforce. So I think we need to watch this space on that and see what the implementing regulations tell on this. But it's quite a significant change to recognise the future of work. So there are a few other changes that I'm just going to touch upon because I'm conscious of time, but will impact things like hiring going forward. So we've got this new concept that where an employee resigns during their probationary period to join another employer in the UAE, the former employer will be able to recover the recruitment costs that incurred from the new employer. It's not quite clear how that will happen in practice, and that will presumably be addressed in the implementing regulations. But I mean, when talking to recruitment teams, I think at the moment I'm saying to them, we really need to make sure that we are doing our proper due diligence on candidates, as we always would. And part of those checks need to be, is the individual still in their probation period with their current employer? And on the topic of probation, previously it was possible to terminate employment without notice. But from the 2nd of February, employers will now be required to provide 14 days notice of termination during the probation period. The labour law also gives different notice periods to an employee who wants to leave during their notice period. And that is 1 month if they're planning to remain in the UAE and take up another role in the UAE, and 14 days if they're planning to leave the UAE. Again, important, further enhances the importance of proper management of a probationary period. The new labour laws also introduced a minimum wage. It hasn't specified the amount yet, but this is quite groundbreaking. This is very new for the UAE. So at the moment, we've only really had minimum wage be a factor when it comes to visa and sponsorship of dependents, or perhaps to open a bank account. But what is envisaged as a new labour law is that the ministry will set a minimum wage.
Question, Liz, if Accenture was asked by the government to weigh in with recommendations on minimum wage, are you guys ready to do it?
That's a good question, John. I mean, I think it's probably going to take a lot of detailed analysis, really, right? Because we have so many different types of work.
That's why we need Accenture to do it.
Sorry?
That's why we would need Accenture or somebody like Accenture to do it.
I think you're absolutely right. I think we will need remuneration consultants. We'll need a broad, we'll actually need a cross-functional group of people to think about what that might need to be, benchmarking the cost of living and other things within the country, and also the viability of maintaining the workforce as they want to. It's a very complicated area to go into. Obviously, it's been achieved in lots of other countries around the world. So I'm sure some of those best practices will feed into the ministry's thinking on how they set that minimum wage.
Super.
I mean, I'd anticipate, you know, when we talk about minimum wage, we're talking about the very lowest wage that may be paid for possibly the least skilled work, aren't we? So for many employers, this won't be a big significant change for them because will already find themselves paying a significant amount more than that. But yeah, it's interesting that it's now being formally introduced here. Charles talked a little bit about the wider protection for discrimination under the new labour law, and linked to that, the labour laws introduced a new protection for employees against bullying and harassment in the workplace. Previously, harassment was dealt with under some of the other laws, so for example, the penal code, but that means if you've been harassed, you need to go to the police and there's a different process. Whereas now we're seeing a clear basis for claim in the employment context. And the labour law doesn't set out specific penalties attributed to claims for bullying or sexual harassment, but it does set out a list of penalties that may be imposed for breach of the law, and they range from 5,000 dirhams to 1 million dirhams. So that's quite, you know, if you didn't already have a good rationale for making sure that you have robust policies in place and that you have effective mechanisms for reporting, investigating and responding to these types of allegations, you know, those types of fines that have a multiplier effect when a number of employees are affected, will help to reinforce that, I'd think. And then finally, I just wanted to flag that there are some new leave entitlements scattered across the labour law. There's been a change to maternity leave. It's increased to 60 days with 45 days paid and 15.5 pay, and no reduction in pay when an employee hasn't completed a year of service when they go on maternity leave. We've also seen adjustments to nursing breaks, an unpaid sick leave entitlement, and an introduction of bereavement leave and study leave. So the new law also consolidates a resolution that was issued in 2020, which introduced 5 days parental leave to be used within the first 6 months of a child's birth. But the bereavement leave and the study leave are entirely new. So 5 days bereavement leave and 10 days study leave for those who've completed 2 years service is now going to be an entitlement under law. Okay, and I think probably I'm out of time. Charles has addressed pensions.
You are, but can you just real quickly address the pension in lieu of gratuity? I know that's a huge issue, but lawyers in the UAE, I won't mention any names, over the years have made money on that issue because of the lack of clarity and claims that, you know, should or should not have been made in that regard. Does the new law give clarity to that? And for those, for the audience, what I'm talking about is the UAE has a formula for end of service benefits, but in the old law, there was a provision that if you were compensated by a pension scheme of some sort, then you would not be able to double dip. So those became a perennial problem. I'm wondering, Liz, does the new law provide any clarity there, or, you know, are we done with those disputes, or?
I don't know. To be honest, the new law doesn't address pension, a pension or savings provision in lieu of gratuity at all. We'll wait to see if the implementing regulations come in with that. But you are absolutely right. The previous arrangement was fraught with complications because understanding what type of scheme could properly replace the entitlement to gratuity was complicated. I mean, and on a strict interpretation, it needed to be something that was established in the UAE, and you had to make sure that it provided the equivalent amount to the gratuity entitlement. So it wasn't super flexible, and there were still disputes because sometimes employers tried to rely on an overseas pension scheme that had been provided at group level or in the country that they were first employed in lieu of gratuity, and that wasn't going to be enough to satisfy or extinguish the entitlement to gratuity. So new law doesn't tell us anything, and doesn't at the moment even allow you to provide a pensional savings scheme in lieu. But I would certainly expect us to see more on this. You know, as Charles mentioned, we've seen the DIFC introduce dues, which is a locally regulated employee savings scheme to which employers are required to contribute. And I mean, perhaps we'll see something similar be established onshore. Because I know from the authority's perspective, and one of the reasons why the DIFC introduced dues was they wanted to make sure that the gratuity accrual was happening, and that it wasn't going to be that it was going to be protected for the employee, as well as also, I suppose, encourage employees to think about savings and future provision, given that we don't, as expatriates, have it. We're not enrolled in the state pension provision. So I think we'll see more. But at the moment, it's gratuity or nothing.
Understood. We at the moment are the 1 hour is up. I have a question for the other Liz, our CEO of AmCham Abu Dhabi. Can we go 10 minutes over, Liz, with some questions to answer questions?
Of course we can. Look at the high level of engagement. Get those questions answered,
Okay.
Jeff.
And I'm sorry, Liz, would you mind? I don't have the questions in front of me. I see them sort of coming in and then they pass through. Would you mind posing a few of them or sending them to me?
Sure.
Do you have?
I have them right here on the chat, Mr. McGowan. So we'll start with a general question. The slide deck from this presentation will absolutely be available in the email that will be sent to you, along with a survey about your satisfaction and a copy of this recording. So don't worry, you'll get that deck. Let's go to a question here. We have some questions about free zones, not enabling labor card sponsorships for golden visa holders. And a question, I'm not sure who to direct that to. Would that be you, Abir, or who should answer that?
Happy to chime in here, Liz, on that particular question. So for majority or the major free zones have and jurisdictions have already introduced some sort of a work authorization scheme that supplements the golden visa. However, obviously, and we understand there may be some that are still, work in progress or trying to get those on their technology or just sort of wrap it up. So until then, I think it's important for the employers, one, to make sure that they keep an eye on the updates from that particular jurisdiction, follow up thoroughly on when those permits are going to be available, because it remains the employer's responsibility to make sure that their individual or their employee is work authorized. When the golden visa was processed, the work authorization that they initially held was canceled to allow for the golden visa processing. So while it would be understandable from a federal perspective that, when the jurisdiction governing your company did not have it available, you weren't able to issue it, you would see that there wouldn't be an announcement once it becomes available. So the employer has the responsibility to continue to check and follow up and make sure that as soon as that's available, that they issue it. In the interim and in the meantime, things like employment contract should be, if they're not in place, should be, complete. They need to document that this individual is still an employee of the particular organization, but they are on golden visa or a silver visa sponsorship. For many of our clients, specifically those in free zones where you need to provide a final settlement, we're working with the free zones to issue instead a letter saying that they're still an employee, They're only canceling the work authorization because they've been provided a golden visa, and as soon as that's complete, they'll go ahead and process their work authorization. So I would say if in your jurisdiction is not available, it will be shortly. We know some of the free zones took a little bit longer to catch up. So just keep an eye on it, and don't expect a general announcement. They're usually not going to be sent. You just need to continue to monitor it and issue it as soon as it's available.
Great. Now this question is interesting. Can employees be asked to work over 8 hours a day? No, says Charles. Okay.
There, I unmuted myself. Yeah, the answer right now is no. Well, no, it's not really no. If an employee does work over 8 hours a day, the overtime provisions of the labor law are triggered. And there are different overtime rates. You've got to pay the employee depending on when they work overtime. If it's late at night, if it's weekends, if it's annual leave, things like that. And so you can work an employee over 8 hours, but if that's an employee who's entitled to claim overtime compensation, then the employee is entitled to overtime compensation. A lot of people think that as long as we don't go over 48 hours a week, there's no overtime. Not so. The caps are two separate caps, daily and weekly. So if you work over 8 hours a day or over 48 hours a week, the employee becomes entitled to overtime compensation if the employee benefits from the overtime rules. Now that's a big if, because there's space in the regulations. Let me just back up a little bit. This is true of the labor law. It's true of many of the other new statutes that have come out in the past 3 or 4 years in the UAE. There's a general statute that provides a framework, and the cabinet or the individual ministries are given authority to promulgate regulations that really are the meat of the regulatory scheme. So the real important measures are going to be the ones that set the detail out, that answer all your questions out there in Zoom land. Those will be in the regs. So we have to wait and see how they're going to handle things like pensions and savings schemes. We're going to have to look and see how they define the employees that get overtime and those that don't. We're going to see how they handle things like whether basic salary or total salary is used for certain types of payments. We're going to have to wait and see what they do with this concept of working days. It's in the gratuity calculation. So there's some ambiguities, but there's also tremendous scope for the cabinet to take action, and then also take corrective action by cabinet resolution. It's a much faster process than going through the legislative process. And so we're seeing more and more of that enables. That's why things are happening so fast, because more and more regulatory responsibility is being done by the cabinet and not by the legislature as a whole. So anyway, that's a kind of roundabout, but this is an example of that. We'll see a lot of cabinet regulations under the labor law, and that'll clarify a lot of these issues.
Well, here's a challenging one. I'm not sure who this is, but as the transition from unlimited to limited contracts will be happening, which start date will be mentioned? The original date of the employees joining, and also connected to this, how does the end of service will be calculated for the past years? And then we just kind of mentioned the calendar days, working days. That's a very good question.
Yeah.
Who would like to take that? Liz or Charles, Lapierre, who?
Well, I mean, for the gratuity calculation is based on term of service. And if you were hired in 1990 and you're still working today, even if the law changes, your gratuity, if you say, get fired a week from now, is going to be based upon your original date of joining back in 1990, assuming it's the same employer, same term of service. So the change of law doesn't change that. It doesn't take away acquired rights. What is different now is it's much more difficult. In fact, I don't think it can be done. You don't lose your gratuity if you show up to work drunk and get fired for that. And under the old law, you can lose your gratuity for that. Not anymore. if you resign before finishing 5 years of employment, you can lose your gratuity or part of it, not anymore. So there are changes like that, but the calculation is still based upon the date of joining. You know,
Just
however remote in time that might be.
a
Go
quick
ahead, John.
follow on that, Charles, on that point. So under the new law, are all contracts are limited, that's clear.
Yep.
But are all contracts, do they all have to be for 3 years limited, or could they be for 2 years limited? Do we know that? Or is it 3?
Yeah, I think it's 3 is the maximum.
Yeah, it is. Three is the maximum. So we've got some, I mean, how you determine where you land on that fixed period is not quite clear yet. And it might be that you choose to link it to visa. But yeah, it's up to 3 years.
Okay.
Jason has some questions about, going to visa eligibility and visa extensions and that kind of thing. And I'm not sure there's a definitive answer to those questions really, but yeah, plenty of people work under 2-year specified term contracts or 1 year, but the old 5-year you can't use anymore. It's got to be 3-year or less.
Gotcha.
Well, lead into Jason's question. He's got a specific ask. Now he's got an employee visa that expires last week of Feb, but he needs this employee until April with his current contractual agreement. So how does he put him under temporary? Does he put him under part-time? How does he approach that without having to bear the cost of all that, renewal?
Yeah. Well, can I take that? Abir, tell me if I'm wrong here. Here's what I would do. I'd put the guy, I'd say, look, you can give the person up to 3 months notice of termination. Just do that. He wants to work until April, February, March, April, 3 months. Give him a 3 months notice. This is garden leave. And so your last day of employment is going to be the day in April that's 3 months from now. I think if the visa expires, you should renew it. And then cancel it or transfer it when the guy leaves your employment. But I don't think there's any way around. I think you've got to extend the visa. But in terms of the contract, I think if you just put him on notice and make sure it's this long notice, that'll work. Does that make sense to you, Abir, on the visa?
Absolutely. The maximum, and it all will depend on the jurisdiction where the company is located, etc. But the maximum grace period would be 30 days from the day of expiry to either renew or cancel. So if the visa is expiring in February, April seems a bit, far off from that 30 days mark, also depending on the exact days. So if his last working day would fall within that 30 days grace period, you may be a bit covered from a paperwork perspective. You just need to make sure that you cancel before the end of that 30 days, because you wouldn't get any additional days of cancellation. So post those 30 days, the person needs to cancel and either leave or obtain their new status. Otherwise, there are those overstay fines that you need to worry about. So definitely renewing while it may be a bit of a costly option, it may be the most compliant one. You may opt, again, depending on where you're located and which jurisdiction this permit is issued from. There are free zones and in mainland a 1-year option if you don't want to renew for the full 3 years, and that may be a little bit more cost effective.
Yeah, and just another follow on. I understand there's 1 year, to Jason's question, there's a 1 year period before the changes actually have to be implemented. And it's effective in February, but in terms of changing over the contracts, you have a year to do it. So by that time, the issue will be moot because the employee's going to be leaving. So, that's something to keep in mind as well.
We have just 2 more questions. So we've got a string of questions that have to do with a lunch break. So the question essentially is this: if you work 9 hours, you get a 1 hour lunch break. And what happens if you don't want to take the 1 hour lunch break? Does that fall under flex time? The new rules do state as long as you plug out that 40 hours or 45, whatever's in your contract, you can work 3 days a week. Clarification on that, please.
Gee, how do you do it, Liz, in Accenture? I mean, you normally say, these are our working hours, and you don't get to say yes or no, or I like this and I don't like that. You know,
I think it's quite tricky, isn't it? Because I mean,
Yeah.
the new law still provides for a 1 hour break where an employee works 5 hours, right? So if there was an audit by the authorities, or if the employee brought a claim saying we hadn't had proper rest breaks, there is still a risk, and typically under the labour law you can't waive your statutory rights. So if we get really technical, the best approach is to make sure they get their hour, or at least encourage them to take it. I mean, I think we're seeing more and more employers take a flexible approach to what the day looks like. So it's not necessarily in some I mean, I know some organizations have very fixed on-site working hours, but where that isn't required, we're seeing maybe an extended day, and you do your 8 hours or whatever within that period, and you take a shorter break if you want to finish a bit earlier. But, you know, I think we're starting to see in the market a bit of a empowering employees a bit more to manage their time. And that happened from the pandemic. It was partly triggered by the pandemic, wasn't it? Where we were having to do what we could when we could, and juggle all the other things that were being thrown our way with home working and homeschooling and everything else. And I think that has driven cultural change in workplaces, and it will mean that so long as we don't prevent an employee from taking their rest breaks, then we can allow them to be a bit more flexible.
Yeah, don't prevent them. That's the main thing. Yeah.
And our final question is, end of contract, what is the basis that an employee will send a resignation letter? It should be based on the first day of joining or the date of the residence visa expired. The reason of the question is some employers will not process immediately the residence visa after getting the employment visa. There's a delay. This listener is for clarification. Any idea?
Yeah, I mean, you're supposed to give at least a month notice if the employee wants, this is an employee who wants to resign. And yeah, it's a resignation letter. I mean,
if you wish.
Sure, I fully understand the question, but
Yeah, I'm trying to read it again. Just
what
to,
is the basis the employee will send it in?
Yeah, it's from, yes, Doris. I think it goes like this, Liz. The employee, of course, can resign. Okay, the employee has the right to resign if the contract says so. So but resignation has got to be done in writing, and there's got to be at least the notice required by the statute. And so if the contract says 1 month notice, the employee gives 1 month notice in writing, and then the last day of employment is the month after the notice is given. So if you give notice today, which is the 12th of January, it means your last day of work is the 12th of February, or 1 month away, or 30 days. Maybe it's the 11th. No, that's right. Take away 3 days. Yeah, 9th of February. Okay, whatever. I'm not an accountant. I don't count. But that's your term of service. Now the visa is a little bit different. The visa doesn't, you can go about transferring, terminating the visa, whenever. You've got 30 days grace period, but the actual term of service is going to end 30 days following the notice, and that's when you calculate your gratuity and all the rest of it based on that date.
yeah,
And
just
then
to chime
go
in
ahead,
with
Abir.
that. Yeah, for the visa bit, and I think if I understood this correctly, the person's perhaps trying to see when their visa can be deregistered with the employer they've resigned with. And that's because a lot of employers would hold the visa cancellation until the last few days to 1 week of your notice period. And that's an acceptable practice from the government, because obviously the employer needs to make sure that you're work authorized within that month notice period that you're serving with them. They cannot cancel you the next day from your resignation so that you can go and apply for a job with someone else, and then you hold a residence permit with your new employer, but you're serving a notice period with your current employer. That doesn't really work, and I know a lot of people get frustrated with this, but that's a right practice by the employers. They can keep the cancellation until the last week to a few days, again depending where you are and how fast the cancellation can be processed, and cancel you then, because you need to remain work authorized with them until your notice period has been complete, and you cannot hold the residence permit with employer XYZ while serving your notice period. I don't know if that's what the person was necessarily asking about, but that's at least what I understood, and happy for them to reach out separately if they need further clarifications.
So Doris, you did ask me privately if there anything else you would like to add. Please unmute yourself and you may have the last question now.
Hi, good evening.
Good evening.
Good
Yeah.
evening.
I just want to clarify regarding the resignation letter. Like, for example, 2 years contract of an employee. Then the day of joining is, let's say, August 2019. And her visa didn't process immediately until he got the employment visa. There is 3 months. So from August, September, October, November, the expiration of the residence visa. On August, the employee sent a resignation letter, but the employer didn't agree. He said, you have still 3 months to work with us. So keep that 3 months before you can send the resignation if you will not renew the visa. So I give you one month grace period to find another job. That is what I mean. Is the employee will based on the first day of joining or the end of the residence visa?
Well,
Immigration wouldn't really take those technicalities. I think this is more of a labor dispute on, more than an immigration dispute.
yeah, Doris, it's really, and this is maybe the old labor law where specified term contracts really were for specified terms, and you couldn't terminate them in advance like you can once the new labor law takes effect. But let's look at your question. When the employee, you signed a contract that says you're beginning work on 1 August 2019, that's going to be the date they use. And so a 2-year specified term is going to be 2 years from that date. The visa is an administrative thing that gets done. It takes some time, maybe. And there are delays, and everyone knows that. But the day, and if the person especially is at the workplace working from that start date, from August the 1st, everyone is going to treat that as the start date, and not some later date when the visa happens to be issued. So I think that's the way you count.
Yeah.
But now under the new labor law, it won't even matter, because an employee, if the contract lets you resign with notice, even if it's a specified term contract, you can resign with notice. And the notice period begins on the date of resignation. So you have more flexibility under the new labor law.
Great stuff. Well, Liz, if we don't have any questions, I think we need to wrap it up. LAC, we like to stay more or less on schedule. Is there anything else in the queue?
No, sir. I just want to personally say, Ms. Williamson, yourself, Mr. Laubach, and of course, my sister Abir. Wow, what an panel. Last words go off to you guys.
Yes, indeed. Yeah. Any final comments from the group?
Nothing but to say, definitely exciting times, a lot of changes. I think we're heading in the right direction. I think there's still a lot that needs to be done, but we're heading in the right direction. I think the UAE is definitely trying to cater to a big and diverse group and to cater to all of those new changes that are happening around the world with, what people perceive as profession or as work. And that's a great thing. So happy to be working in immigration and having oversight on immigration and employment in such times.
Thanks a lot, Abir. Charles, any predictions on when we'll get the regulations?
Well, I mean, I don't know things like that, but I expect it'll be pretty quick. I expect it during February, because it's important to know where you stand. And if anything, if you make a prediction that the UAE authorities are going to act quickly, you're probably going to be right. The way things are going nowadays. So I expect it February, March, not a long time. And look, we put this together. We sent notices out, 6 days ago, Liz? and we got obviously a very high level of interest. So Abir and Liz and John, if you want to do this again about the regs in like a month or two, I'd be more than happy to spend another hour and a half with you guys.
That's a great
I
idea.
I think the level of interest is high and it's worth doing this. So, I'm ready. And thanks so much for your time, Abir, Liz, John. I know how much time it takes to prepare for these things. It looks easy, but it's not. So thanks for all your hard work. I really appreciate it.
Thank you for your leadership of LAC. Liz Williamson, any final comments?
Yeah, I think Charles is right. And don't take drastic actions now. Let's wait and see what the implementing regulations say. But the new labour law has paved the way for some quite interesting changes and flexibility in a progressive modern workplace. So I'm very happy to regroup in a month or two and deep dive into what those regs say.
We will do that, and I'll consult with our CEO on that, and we'll come up with a date, and as soon as the regs come out. Liz Beneski, thank you as always for coordinating. Sharat and your team, this has been great. I've learned a lot. I'm sure many in the audience have. So thank you for joining the Legal Affairs Committee, everybody.
Bye-bye.
Bye. Thank you.
Take care.
Thank you, John. Thank you, Liz.